Hey out there, legal warriors. In this video, I'm going to cover 3 huge mistakes to avoid in a hit and run case in Washington State. Even if you're not charged with hit and run, this is still good information for you to know, so stay tuned. My name is Attorney Lance Fryrear, and I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm going to jump right into it. What are the 3 huge mistakes to avoid if you get charged with a hit and run or involved in a hit and run case in Washington State? The first and biggest mistake that people make in a hit and run charge isn't what you think it would be. I think the biggest mistake is not involving your insurance company, right? Most people think, hey, I got involved in a hit and run. I don't want my insurance company to know about this. There might be some damages I need to pay. Maybe I'll just pay out of pocket. Maybe it won't be that bad, and I don't want my rates to go up. Well, why is this a mistake? Because hit and run, either hit and run attended or hit and run unattended, those are 2 different non-felony hit and run charges. For a non-felony hit and run, there's a statute in this state called compromise of a misdemeanor, and there's a video that we have about that, and you can watch that if you want, but I'll cover what compromise of a misdemeanor means. Compromise of a misdemeanor says that if a victim of a crime has a civil cause of action, and let's face it, a hit and run case usually has monetary damages someone could sue you for. If a victim of a crime has a civil cause of action and they appear in court, and we say that means in writing, and state that they've been civilly satisfied for their damages, that means sign something that we draft called a statement of civil satisfaction, then the court in its discretion, which means they look at your record and the circumstances, they can dismiss the case, which means it goes away. So why would we want the insurance company involved? Well, we have insurance for a reason, right? And the damages on a normal accident case might be $3,000, $4,000, $5,000, $6,000, who knows? And that's a lot of money to pay out of pocket. And so by getting your insurance company involved and getting the other party made whole more quickly, they're probably going to have a more positive attitude when your legal team reaches out to them to see if they have any additional out-of-pocket expenses to claim. If your insurance company has covered it, they probably don't. Then they're much more likely to sign something saying they've been satisfied. And then we can use that signature on the statement of civil satisfaction to file a motion with the court under the compromise of a misdemeanor law to get the court to dismiss the case. And so it's sort of a nightmare for us when a client comes in 4 months later and they've not told their insurance and the other side isn't made whole yet and everyone's all mad. Well, it's a lot harder to get that person to do something that might end up helping a client in that situation. So involving the insurance company is a good idea. And so that is what we think would be what you want to do. So the second biggest mistake I see people make is not taking this type of case seriously enough, right? Is thinking it's no big deal. If this is your first criminal offense, you may not understand how the system works, but let's say why it is a big deal. So for a hit and run unattended charge, which means you hit a mailbox or a parked car with no one in it, the maximum penalty is 90 days in jail and a $1,000 fine. Okay, that doesn't carry any license suspension, but if you miss a court date, you do get a warrant for your arrest and you get to go to jail, okay, when they arrest you for missing court. The other type of hit and run charge is way out of line with how serious it is, in my opinion. It's way too serious for compared to other types of laws. Hit and run unattended means you were in an accident that had somebody else in the vehicle, but you didn't stop and give the full information. You might have got scared. You might have only given part of the information. You might have been afraid of the other party. You might not have known you were in an accident. That happens all the time. Okay, but in that case, hit and run unattended, the maximum penalty is a $5,000 fine and 1 year in jail, like most gross misdemeanors, all of them actually. But the bonus that makes it so terrible is, and so the negative bonus is, if you get convicted of that, you lose your license for a year, right? A year. If you first offense DUI under a 1.5, you lose your license for 90 days and you get an interlock license to drive anyway during the suspension. A hit and run attended means you didn't give all the information, maybe you didn't know you were in the accident, but you still got convicted. Way less irresponsible behavior. You didn't, purposely endanger anyone. It's more like a regulatory offense, and that's a good reason for the law, don't get me wrong, but you weren't impaired, okay? Well, in a DUI, you're getting a 90-day suspension and you can still drive with an interlock license. On a hit and run, you get a 1-year suspension and you can only get an occupational license to and from work only, not anywhere you want like in a DUI. So you tell me if that makes sense to you. So you have to take it seriously because it's sort of an outdated law in my mind, and the consequences of a suspension or of a conviction are pretty draconian, I think, due to this suspension. And so you need to take it seriously, you need to show up for court, and you need to get yourself an attorney, because in a hit and run case, we have more ways to get it dismissed than other cases, because it's one of those few types of crimes where there's a monetary amount of damage that's easily identifiable and easily payable through insurance, right? So it's just a matter of sort of getting the paperwork done in a correct way and getting the other driver cooperative enough to sign something where it gives us an ability to ask the court to let you go. And if your case gets dismissed, you're not suffering a suspension, you're not going to jail, you're not having to pay a fine. There might be a court cost on a compromise, but not a fine. And so take it seriously and get yourself an attorney, all right? I think the third and final thing I want to cover is the biggest mistake people make in hit and run cases is when they do get an attorney is paying too much for the attorney. It's one of the only times I'm going to say that, okay? At least in my opinion, a hit and run attended or unattended charge, unless it's a unique circumstances, a particularly difficult looking case, it shouldn't cost as much as defending an assault or defending a DUI or cases like that, because there are more identifiable ways out of the case, and for the most part the prosecutors aren't getting super excited and super upset about this type of case. It could happen in the right fact pattern, but generally not. So your mileage may vary, as people say. So what you want to do is you're going to get some type of quote from defense attorney, and you don't ever, when you don't want to pay the least, but at the same time you might want to ask a question like, what do you normally charge for a DUI? What do you normally charge for assault? What do you normally charge for a hit and run? Or how much are you charging me? And if the rate you're being charged is the same as the more serious sounding charges, well, it's something to consider. You might want to ask why, and there might be good reasons, and this is just my opinion. I've done defense work for over 20 years, and I've one of the bigger firms in Washington State for criminal defense, if not the biggest for criminal only. And so we've always tried to look at, hey, if the case seems a bit easier, we're going to charge less than if it seems a bit harder, because criminal attorneys generally charge flat rates. So what we want you to do is get you out of this without consequences, while still having an ability for you to still maintain your life, right? And that's why we want you to use your insurance. We want you to take it seriously, and we want to make sure that you only pay a fair rate in dealing with the case, which hopefully isn't as serious. Now, if you got a worse criminal record, there may be things that complicate that. If you got a bad criminal history, you might not be able to do a compromise, right? If there's no way you're going to be able to pay for the damages, the insurance won't, you might not be able to do a compromise. If you've got really egregious facts, right? You ran into a car with 6 people and you flipped them off and just took off, well, that's pretty bad. That might be harder. But for the most part, typically speaking, non-felony hit and runs, and a felony hit and run means usually an injury with someone in the car, not just property damage. Non-felony hit and runs, there's more ways to get a positive result in those than some other types of cases. Nothing's easy, but at least there's more ways to avoid that terrible law. So I hope you found this useful. If so, please like and please subscribe. More people will get to see it. And even as important, if you're in the type of situation where you have a hit and run charge and you need some help, feel free to reach out to my firm. We've done this for more than 20 years and handled hundreds of hit and run cases, and usually with a good result. If you give us a call, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.